All righty. Let's go on the record on cause number DC 199701, Vanita Cole versus Denise Jackson. Counsel, make your appearances.
Rachel Hatton-Adam, counsel for plaintiffs Vanita and Van Cole.
And Anthony Lascalia, attorney for the defendant, Denise Jackson.
All right. We're here on a motion to strike a counter affidavit. Why don't we proceed?
Yes, Your Honor. Plaintiffs have filed the motion to strike the second counter affidavit of Dr. Beccaria. A brief background, Your Honor. This case was originally filed back in July of 2019, July 10th, 2019. This is before the new 1801 counter affidavit, 1801 rules took effect. The defendants initially filed the first counter affidavit of Dr. Beccaria back in July of 2020, July 17th. Plaintiffs moved to strike it on October 19th is when we had the hearing for our motion to strike, in which Your Honor granted our motion to strike and struck the controverting affidavit of Dr. Beccaria. At that hearing, Mr. Lascalia was present, was also representing the defendants, and after Your Honor granted our motion to strike, Mr. Lascalia requested leave, orally, if you'll remember, to which Your Honor denied leave to amend or refile. However, the defendants, without having Your Honor grant leave of court for them, have refiled the controverting affidavit of the same doctor for a second bite at the apple. And that was later that month, 10 days later on October 29th. We again moved to strike as even the second untimely and without leave counter affidavit, even that one does not meet the 1801 standards. Trial is currently set for the 12th of this month, January 12th, but there is an agreed motion for continuance on file. So that's some context for Your Honor. We do not believe that the second counter affidavit, the second attempt meets the 1801 standard, for it still does not give us reasonable notice as for the true basis in how Dr. Beccaria has come to his opinions. Putting all of that aside, this controverting affidavit is untimely. It is an attempt to just go against Your Honor's ruling and still try and file. The defendants raised this issue of their lack of timeliness in their response. They are on notice of this issue. And for the record, we do strongly object to this counter affidavit, and we believe it should be struck in on the basis that it does not follow the timeliness requirements of 1801. They did not seek Your Honor's leave to refile with the same doctor this controverting affidavit, and still this controverting affidavit on its face does not meet the 1801 standards and does not give reasonable notice as to how it is that he has formed his opinion.
Okay, response?
Judge, yes, I just want to start in neither motion to strike, there's any objection to qualifications or timeliness. In plaintiff's last motion, timeliness is not mentioned even at all. We received additional affidavits back in October, and we timely followed this controverting affidavit 2 weeks later. We also mentioned that Dr. Beccaria, in fact, this year in other Dallas courts, his testimony on billing has been accepted. And I actually included that motion in order in our response. Dr. Beccaria, in his affidavit, even states that the fees exceed what is considered usual and customary in Dallas County. He even has in his affidavit that he is familiar with the reasonableness and customary charges for pain management medical doctor services in Dallas and surrounding counties. And Judge, because we received additional affidavit back in October, we believe because this case is still governed under the old pre-September 1st, 2019 rules, that we have the opportunity to controvert this additional treatment. So that is our argument, Judge, but I do want to note that there's no objection to timeliness in any motion to strike in this case. So that's the first time we're hearing this.
Okay. He says that you didn't bring up timeliness. Is that correct or not?
It is correct in that it wasn't a part of the included in our motion. However, having looked at their reply, they cite no source as to any a lack of including it in the actual motion is waived, I believe. As the law stands, as long as it is waived, it's on the record. It is part of, it can be considered by your honor as a basis. Now, as far as the new the new affidavit that they are seeking to, in their stance, timely controvert, the only difference in the affidavit or the counter affidavit that was already struck and the affidavits it was controverting, and the affidavit, the new counter affidavit is seeking to also strike, is one visit. Dr. Vaccaria's counter affidavit that is before the court today is seeking to controvert all of the same charges with the same basis that the court has already considered, but for that one subsequent visit. So at best, it is our stance that their controverting affidavit should be limited to the one follow-up visit that occurred in July of 2020.
So let me make sure I kind of understand the history here. So there was an affidavit filed, the defendant filed a counter affidavit, then did you file an amended affidavit?
Yes, because after the defendants had filed their counter affidavit, Vanita Cole went back and saw the pain management specialist one time. So it was a second affidavit that was filed after the initial counter affidavit was already before the court. So that was not considered in that report that we have already discussed at the.
And then was the counter affidavit filed to the amended affidavit, was it timely? Assuming the amended affidavit is new?
Correct. That would have been, yes, that would have been timely for that one particular visit.
Did you file a supplemental or amended affidavit?
We filed a new affidavit. We didn't call it supplemental or amended. It was the affidavit. It's the way it reads, Your Honor, is the affidavit of records custodian of epic pain and orthopedics regarding patient Vanita Cole. So we did not designate that this is a supplemental or amended. It was a new affidavit.
That's kind of a new one. Because my initial thought was just to go ahead and grant the motion to strike based on timeliness, but because there's a new affidavit, I'm not really sure, and I don't remember this. Interestingly, I don't know this issue's ever come up. I've been on the bench for over 14 years now. I don't know that this exact issue's come up. Do I look to the original affidavit or the new affidavit? Is there any case law on this that says that when there's a new affidavit filed, that does it relate back, or does it just relate back as to the original treatment? Can they counter the whole thing because there's a new affidavit? I don't know. Do you know is there any case law on that?
I'm sorry.
Pardon. If you can, I'll let you speak.
Okay, Judge, I just want to say the affidavit that was filed, it was filed 10/6 of 2020 for $25,752.66 as one affidavit. We filed a controverting affidavit almost immediately 2 weeks later on October 28th, 2020. We believe that this case, since it is governed under the pre-September 1st, 2019 rules, that we have the opportunity to controvert that affidavit, Your Honor.
How much was the original affidavit that was filed for? You said the second one was for about $25,000. What was the original affidavit?
The original affidavit, Your Honor, was for $25,010.16. The newest affidavit is for $25,752.66. The only difference is the last and final follow-up of $742.50.
Okay. So you say that, did you have any case law on that, either side, on the issue that I suggested or brought up?
Judge, I can do some case law and provide it to you ASAP.
Yes, we can provide a brief for the court.
We believe because this is under the pre-September 2019 rule that any new affidavit filed, we have the opportunity to controvert it. So, and there's been
just give me some case law on that, because to me that's a dispositive issue. Is if there wasn't a new affidavit filed and you just filed a new counter affidavit, then it would be, in my mind, it would be untimely, and I would strike it. But as to, because there's this new affidavit, I'm not really sure how that plays into this. Can you counter the entire amount, or can you just counter the new amount, the new treatment? And I don't know the answer to that. So it doesn't matter if it's called an affidavit or a supplemental affidavit or a counter affidavit or a amended affidavit, and that might be relevant as well. So why don't you guys give me some briefing on that, and as soon as you can. And when is this case? You said there was this case set for trial when?
Our current setting is for the 12th, January 12th. However, there is an agreed motion for continuance on file.
I just signed something like 150, 200 orders. I don't know if that was one of the ones I signed. There was a lot of continuances in there, but when did you ask it to be reset to?
We haven't judged. We didn't put a number of, or a proposed trial date in that order, but we can discuss it amongst ourselves and provide you a date, or however you want to proceed.
I just don't know if I've already signed it and given a date. So, one thing to think about is for live trials, live in-person trials, I have no idea when we're going to start those up again. We have a vaccine, but even optimistically, it says what I've read is the general public is not going to be getting the vaccine until sometime in the summer. So one option would be, if either side is interested, we're still kind of debating and hearing the judges about how to deal with remote trials. But if you are interested, either side is interested in being on a remote trial docket, just email my court coordinator. You don't need to make a decision now, but you'd be able to, I think, get to trial a lot quicker if you're willing to do remote trial. Realistically, this is a 2019 case, we're probably not going to be trying those until sometime next year, even if we reset them. So, and maybe longer. So if you're willing to do a remote trial, email my court coordinator. But if not, we'll go ahead and just reset it the normal course. Okay.
Yes.
Anything else, guys?
We'll get you that a brief hearing. So, yeah. Judge.
Sounds good. Thank you. You have a good day.
Yeah.
Okay. Papa Brooklyn 2004 versus First Funding Investment. Both sides here.
Defendants here, Your Honor.
Yes, Your Honor.
So I think you guys went to mediation on this. Is that right?
Yes, Your Honor.
And how did that go? I mean, you don't have to tell me the details, but are you guys close, or was that?
No, Your Honor, we're not close.
Okay. All right. Well, I guess, do we need to go forward? Oh, and also you guys submitted, or somebody submitted an order in this case on the temporary restraining order. And the order says, and Tony, let's go on the record on this. DC 2017691, Papa Brooklyn 2004 LLC versus First Funding Investments, Inc. Counsel, make your appearances.
I'll go, Your Honor. This is Caleb Moore, defense attorney for First Funding. Present here on the Zoom call is Charles Gum, an officer for First Funding.
Ms. Cole? Did she disappear? I think she disappeared.
Hello?
Ms. Cole?
She disappeared from my screen as well, Your Honor. I saw her there for a second.
Yeah, she said hello. Well, not sure what to do there. Rhonda, can you call her and find out, Ms. Cole, and find out what's going on? Seemed to kind of disappear on us. All right, well, while we're waiting for her to come back, let me talk to the Wildwood Natural Corporation versus Key P-Na. I think I saw both the attorneys here for that.
Yes, Your Honor.
Good morning, Your Honor.
Okay, so this is I guess you guys have 2 hearings set for today, is that correct?
Yes, Your Honor. And they're kind of related as well.
There's a motion to compel that's set right now, I guess, and then there's kind of I guess, a plea to the jurisdiction and motion to dismiss set in the afternoon. Is that accurate?
That's correct.
Primarily, it's going to be a motion to abate at this point, Your Honor. When we're looking at that, that's primarily what we're arguing is an abatement of this litigation on these Tufta claims.
Okay. I'm not sure what's going on with this other case where that attorney went. She just disappeared on us or what happened, but do y'all want to get started? I guess we can get started, or what do y'all want to do?
Well, one of the things that we spoke about, Mr. Chaudhary and I, we did confer about this before the holidays. And I know this is his hearing and he'll go first, but I know Mr. Song was here also to talk about this. We talked about if the case is abated until it's determined that the plaintiffs have a claim, then this discovery would be abated as well. And so it seems like all these types of hearings today, we might only need 1 hearing today. We might not need a second hearing, depending on whether this case is abated until we decide the underlying cases. Because I know the other side realized this. We have a motion for summary judgment in that case coming up on the 11th, trial scheduled for a month after. We're arguing that we paid them back. We're arguing that it's really only between 2 LLCs and that Mr. Na is not individually liable all as a matter of law because of how it's signed. And we're arguing forgery. So any of those things, just from like a res judicata standpoint, would make it so that these types of Tufta claims don't even apply to our client. So we do think it needs to be abated, and all this discovery issue is kind of moot if that's the case.
Mr. Chaudhary?
Yes, I agree that if the court were to abate the proceedings based on the afternoon hearing today, that sort of moots this motion. That said, we disagree that the case should be abated. We'd like to be heard on the motion to compel this morning, but we're happy to agree to defer a ruling on the motion to compel.
What makes sense to me is that, I mean, I kind of agree with Mr. Rowland that we would hear the abatement first and then the motion to compel second.
That's fine, Your Honor.
Okay. Do y'all want to do that now, or Mr. Chaudhary, or do you want to do that in the afternoon?
In the afternoon, Your Honor.
Okay. Mr. Rowland?
Okay, that works for us, Your Honor.
Okay, well then we'll hear both the motion to abate and then if we need to, the motion to compel, I guess in the afternoon.
All right, thank you, Your Honor.
Thank you, Your Honor.
Guys, see you
shortly.
See you at 2:15.
Thank you. See ya.
Thank you, Your Honor.
Mr. Moore, I'm not sure what to do here at this point. Do you want to call Ms. Cole and find out what's going on? Or Rhonda, have you been able to reach Ms. Cole?
I'm happy to call her. I can't think of one time she's ever picked up my call, but I can mute and give her a call right now. I don't know if Rhonda had any better luck. She just emailed me and she's saying she cannot log back on. I could email her to have her call in and talk to the court about what's going on. I will note that she doesn't have a witness here, at least on the Zoom, to support her motion for injunction, so she could potentially admit any exhibits or any evidence.
And my understanding is the TRO is expired, right?
Yes, Your Honor. From what, at least from my call to the court clerk on, I believe it was the 30th, they never paid the bond, so it never went into effect. At least that was according to the clerk on the 30th when I called. If they did something between now and then, I wouldn't know. But it hasn't shown up on the court's docket entries. Like when I post a bond, there's a little financial statement and a receipt and a form that I fill out that always shows up on the Dallas District Clerk's list of activities on a case that anyone can see. That hasn't appeared in this particular case. So I could email her and ask her to call in, and maybe she can address these issues and whether she has any evidence.
She's trying to log on now, apparently. Let's see.
I'm certainly sympathetic for a technical difficulty.
Yeah, those things happen. Okay, this may be her. Let me see. Hi, Ms. Cole, is that you? The person who just signed in with the last three digits of the phone number 761, is that you, Ms. Cole? Ms. Cole, are you there? You need to unmute. Ms. Cole, are you there? You need to unmute.
Yes, I'm here, Your Honor.
Okay, great. All right, so let's go ahead and go forward on this case. Let's go forward on cause number DC 2017691, BAPA Brooklyn versus First Funding Investments. Counsel, make your appearances.
Kim Tico for the plaintiff, Your Honor. For the plaintiff, BAPA Brooklyn and Jonathan Blunt, Your Honor.
Okay.
Caleb Moore for the defendant, First Funding, and I have with me an officer from First Funding, Charles Gum.
Okay, so we had a court had issued a while back a TRO on this, and there's a new order that was submitted. It's a little unclear to me. I don't think I have the authority to sign this, but it says that the TRO entered on December 1st, 2020 is hereby extended until January 4th, 2021. But it's not an agreed order. I only have the ability to sign an order extending a TRO for 2 weeks. Was this order agreed to, Mr. Moore?
Your Honor, it was, but it's moot at this point. We can have the hearing and nothing's happened or been violated since that date. It's what the court said it wanted to do, and this was the first day we could get. And so since the foreclosure cannot occur until tomorrow anyways, yes, we agreed to it as to it wasn't worth arguing over whether or not you could extend it 17 days versus 14 days or whatever it ended up being.
Okay. All righty. Well, let's go ahead and get started then. We're here on temporary injunction. I understand that the case sent it to mediation. It didn't settle. So let's go ahead and start with the temporary injunction. Ms. Cole, call your first witness.
Your Honor, Mr. Blunt is currently in he has dialysis on Mondays, Wednesdays, and Fridays.
Okay.
So he has not completed his dialysis. However, I did email exhibits to the court to present.
Okay. I saw some exhibits. Let me look at them. Well, let me see. I have some from Caleb Moore. Did you send those to Rhonda?
Yes, Your Honor. Let me try to resend them since I'm having some connectivity issues. Just one moment.
Can you please put me on that email as well, please, Kim?
Absolutely, absolutely. As a matter of fact, I will respond to. I'll respond to your email that has all parties. One moment. Okay, so that's everyone. Okay, it should be coming through.
Have you all discussed the exhibits, the admissibility of the exhibits?
No, Your Honor. I wasn't on whatever earlier email she said she sent, so I was not aware she had any exhibits to admit.
These are, Your Honor, these are actually the the defendant's documents.
Okay. Alrighty. Well, are they any different?
Did you see them?
Are these any different than the exhibits that the defendant sent us?
Only slightly. Only slightly. They are actually the defendant's exhibits with some additional information.
Okay.
I'm curious as to how she intends to authenticate. I haven't received a business records affidavit or anything like that. Does she intend to call a witness to authenticate or to say that her client paid or any of those type of things?
Were those exhibits received?
I haven't gotten them. Rhonda, have you gotten them yet? Yeah, Rhonda hasn't gotten them. Have you gotten them, Mr. Moore?
I did, Your Honor.
Can you take a look at them? Are you going to agree to them or?
No, we're not agreed to their admissibility, Your Honor.
Okay. Is this property posted for foreclosure tomorrow?
Yes, Your Honor. while we're waiting, Your Honor, it appears to me they're trying to make some point out of this on, to the extent that Your Honor has pause and somehow they admit these exhibits, they're trying to claim, it appears, at least from this and from what I gathered in mediation, that Mr. Blount didn't receive these notices that were sent. And I don't know if the court's had a chance this morning early, we filed a little brief in opposition to the temporary injunction. And I've attached, I think it's 4 cases of, probably 100 that deal with and have ruled that actual receipt of the notice is not required, only that it be properly sent. And so I would just point, I don't know if while we're waiting, if the court had a time to take a chance to glance through.
Yeah, I saw that.
Okay, thank you, Your Honor.
And did the court receive the exhibit?
I haven't. And you sent them to Rhonda, I assume, and Rhonda hasn't gotten them either.
She's on the same email with Mr. Moore. I don't know why they're not going through. I'll resend them.
Maybe I just got them. Let's see. Well, let's see. There we go.
Okay, you did receive them?
I did. Yeah, let me. Okay. Let me go ahead and share screen this so we kind of are all on the same page. So, is that Exhibit A?
Yes.
Ms. Cole. So are you offering?
I'm trying to get back on the actual Zoom so I can hear you. So I can see your screen, Your Honor.
Okay.
I can represent to the court that that's the Exhibit A that she sent out to me, Your Honor.
Let me see. I'll try to admit you now.
Okay, so join with computer audio. Okay.
Ms. Cole, are you there?
Yes, Your Honor.
There you go. Okay. So that's your Exhibit A?
Yes, Your Honor.
Okay. Are you offering Exhibit A? Ms. Cole? Can you guys hear me okay?
I can, Your Honor. It looks like she froze again.
Ms. Cole, are you there? Ms. Cole, are you there? All right, she's gone again, I guess. Let's see. Ms. Cole, are you there? This is Exhibit C. Is there anyone here on any other hearings? I think we have another hearing at 10:30. Ms. Cole, are you there?
Yes, I apologize, Your Honor. I'm not certain what's going on with my my connection here. So in any regard, on Exhibit A,
Okay.
the green card that defendants presented as evidence of service.
Mm-hmm.
And it on that one, it purports to have Mr. Blunt's signature. As you can see, towards the bottom of the document, this is also excerpts from defendant's exhibit. This is the first one is the signature on the purported signature on the signature card. The one below it is the actual signature on the loan that is at issue in this matter. The second signature is the guarantee that's actually on the loan in this matter. And then there is Mr. Blunt's driver's license with his signature. This does not require an expert or anything to ascertain that this is not Mr. Blunt's signature. This is a fraudulent document that was presented to the court to demonstrate service in this matter. And as the plaintiff has consistently presented, he did not receive service of this notice. If you go to Exhibit B,
Okay, give me a second. Okay.
if you go to Exhibit B, this again is the green card. If you'll look at the address, which is completed by the mailer, and also look at the signature portion of the document, again, you can see it's the same handwriting. Like I said, it does not take an expert to see that this is the same handwriting. This is Mr. Blunt's signature. He did not date that document. He did not sign the document. He did not receive the document.
Okay.
She just froze again.
Ms. Cole, are you there? Ms. Cole, are you there? Is Ms. Cole, she said, it shows she's still here.
Do we have Exhibit C, Your Honor?
Yeah. Yeah, you
Okay.
cut out for a second.
Okay. So Exhibit C is...
Ms. Cole, we can't hear you. I think this is Exhibit C, though. Is that Exhibit C, Ms. Cole?
Exhibit C shows that this document was simply just created. It does not show that it was ever placed in the mail. It just shows that it was pre-shipment, which means it was never presented to be mailed.
Okay.
So the basic crux of our case is that under Texas Code, the plaintiff is entitled to receive notice and is required to receive notice of this of the acceleration and of the foreclosure sale of the property. Here, the plaintiff did not receive notice. As you can see, the exhibits show that this is not the plaintiff's signature. And he did not sign this document. And furthermore, the green card here shows that the document was never mailed. It just shows that it was pre-shipment according to the U.S. Postal Service.
Do you have anything else, Ms. Cole?
No, Your Honor.
All right. Response?
Yes, Your Honor. So none of these exhibits have been properly authenticated. Their trustworthiness.
So I guess that raises a good point. So, Ms. Cole, are you offering exhibits A through C?
Yes, Your Honor.
Okay. And is there any objection to A through C?
Yes, Your Honor.
Go ahead.
I object that there's been no foundation or authentication of these records. They're hearsay, and they don't meet the standards for admissibility in a hearing at a temporary injunction. I would note that Exhibit C, the tracking number, it does not appear to me matches the purported issues on the green card. For any testimony about who signed what to happen, you'd need the actual person to testify as to what happened. I would note for the court that magically, if they're claiming no notice and they didn't know about this, they filed and got a TRO the day before the foreclosure. So there's going to be some inferences and some cross-examination needed of any witness who's going to claim they didn't receive notice of the foreclosure. So I'll stop there because we're not even close to these being admissible.
And Ms. Cole, I would think you would need an authenticating witness for this, especially to challenge the signature. And it does look different, but it's, I sign my signature all the time. Sometimes it looks very different, sometimes from day to day, but you can kind of tell a similarity. But I don't know that I can make a determination without any type of testimony, expert or fact witness testimony as to the differences between signatures. You said your client is in dialysis. Ms. Cole, are you still there?
Yes,
You're cutting out. I can't hear you.
Your Honor, so I'm going to try to call back.
Are you there?
Yes, Your Honor. I'm trying to dial back in so that I can at least hear you because for some reason it keeps cutting out.
I'm open to suggestions. Do you guys want to maybe reconvene this afternoon? Let me see what my docket looks like.
That would be great if we could, Your Honor. I'm not certain what's going on with my connection.
Well, if we can address a few things maybe on the phone before we do that, Your Honor. If they're not, I mean, they've not requested a continuance, they've never objected to this setting, they never intended to call a witness because they've never had a witness at any of the actual hearings that we've had set. This is the third setting. So it's not like this is a surprise or some, you know, I've been litigating with Mr. Blount and I've heard I'm not saying he doesn't go to dialysis, but every single time we have something that comes up in a case with Mr. Blount, he's in dialysis, and every single case he files is a frivolous lawsuit. And so we are ready to proceed and would like to proceed. I'm sympathetic to the technical difficulties she's having, but it shouldn't make any difference because she has no evidence to admit. Sorry, Your Honor. Thank you.
Your Honor, as I previously indicated, Mr. Blount has dialysis, and I believe I indicated that in the previous hearing, in the first hearing. He has dialysis Monday, Wednesdays, and Fridays. Every week he has dialysis. And so he's never available in the mornings on Mondays, Wednesdays, and Fridays. And typically these TRO hearings are set for Mondays. And so he's never available on Mondays because he has dialysis every Monday.
What time does he get out of dialysis?
He said that he should be out around noon today.
Okay. I'm sorry, I couldn't hear you. What did you say? What time?
Noon, Your Honor.
Noon. Why don't we do this? Why don't we reconvene at 1:45? Does that work for you?
Yes, Your Honor.
I can make that work, Your Honor.
Do you want to ask your witness?
Charles, can you make that work? I don't think you're muted, Charles.
Can you hear me?
Yes.
Okay. Yeah, that's fine. That's fine.
All right. So, Tony, did you get that? We're on the record still, right? Okay. So you guys are instructed to be back at 1:45, and we'll make a determination on this temporary injunction. You guys be safe, and we'll see you at 1:45.
All right.
Thank you, Your Honor.
1:45 today.
Yes.
Back on the same Zoom link.
Thank you, Your Honor.
Thank you. All right. Are both sides here on JAG Financial Services versus Capital Asset Recovery?
Yes, Your Honor.
Is opposing counsel? Ms. Broom, are you opposing counsel?
Yes. No, actually, we're for the movement, but yes, opposing to him. Yes.
Okay. All right. Let me. I'm a little unclear. What exactly is set for today? Is it the motion to seal as well as the motion to compel?
Yes, there's the motion to compel, and then there are special exceptions, Your Honor. It may be easiest since the motion to seal is unopposed. We could probably knock that one out if Grant doesn't have any objection.
No objection to that, Your Honor.
And what is the idea? We're sealing the entire case?
No, we're not. There is an order or a notice of hearing that was posted, of course, and then, posted with the Texas Supreme Court that lays out the parties agreed upon things. So it's not the entire case. Do you happen to have that notice of hearing?
Let me see.
It was filed on the 18th of December.
I will say, when I was trying to read the docket for this hearing, it was very unclear to me what exactly was set for today, because from the court's docket, it looked like just special exceptions. But then that's not necessarily y'all's fault. I'm not trying to fuss with you, but it was unclear to me exactly what was said. So what is it you wanted me to look up?
It's the third-party plaintiff Glasscock's notice of hearing on his unopposed Rule 76A motion to seal court records.
And what day was that notice of hearing?
December 18th.
December 18th, okay.
Yes, sir, at 4:48 p.m.
Let me see, I think I can find it. Okay, so I have a couple questions about this. So the first question I have, was this posted? And did you go through all the requirements of 76A?
Yes, Your Honor, that it was posted. It was posted personally at the courthouse where it's supposed to be posted. Then it was verified as posted, and the posted version with the verification was then filed with the Texas Supreme Court.
Okay.
It as the same.
And then the second question I have is, it lists all sorts of things that you want to seal, like the pleadings that refer to Mr. Glasscock, any exhibits that refer to Mr. Glasscock, any discovery filed referring to Mr. Glasscock, all exhibits that refer to Mr. Glasscock, any trial testimony that refers to Mr. Glasscock, and then specific documents that, you know, let me just do this. I'm going to get Rhonda, sorry, I'm going to ask Rhonda, can you call Rose? Is she here today? And have her come in, because this is what my concern is that at least my experience in the past with the clerk's office, is there a Greg Green on this case?
Yeah.
There's a Greg Green, a Gregory Green. So there's two of them.
Okay, well, he's trying to enter the call. So it seems to be the way this works with the clerks is either you need to seal like a particular document, a full document, they can't seal like part of a document, or you can seal the entire file. This, to me, this order, I'd be glad to sign it. I just feel like it's going to be really difficult for the clerks to kind of interpret, if that makes sense. So
It does.
but maybe there's all sorts of documents here. It says the following pleadings and motions, I assume Carr holding and management response to Glasscock's motion to compel. Anyway, there's 7 or 8 listed on page 4 of your notice of hearing. Are those the documents that you want sealed? Is that the idea?
Those are the ones filed to this point, Your Honor, that would need to be sealed. And we agree that it is generally unworkable. Our desire was to have the file completely sealed because A, it's easier for the court, it's easier for the staff. It's just more coherent. This was executed in an effort to satisfy opposing counsel who was quite opposed, and this was done over a period of better than a month of negotiating efforts to try and resolve something. And this was the proposal that was agreed to by counsel so that this could be presented to the court as unopposed. We do not have an objection to the entire thing being filed or sealed, but you know, obviously that is up to opposing counsel to argue and the court to decide.
Your Honor, this is Grant Schmidt on behalf of Carr. Happy New Year. Can I just address that last point very briefly?
Sure.
So, Your Honor, I know you've had several hearings since our last hearing, but at the last hearing, we heard the court's instructions loud and clear, which was to opposing counsel, hey, we should go about this by filing a Rule 76A. We weren't opposed to them seeking to seal what they initially suggested needed to be sealed, which was any reference not to Brian Glasscock generally, but to any financial or criminal wrongdoing on behalf of Mr. Glasscock. And so when discussing with Ms. Broom, I had the same concern that the court raised, that if we don't identify very specific documents, then it was going to be somewhat challenging. Ms. Broom, as she stated, did suggest we seal the entire case. We, Your Honor, did not feel that was appropriate because there are several portions of the case that have nothing to do with this discrete issue as it relates to Mr. Glasscock, and so consistent with several policy implications of open records and things of that nature, it was our view that the entire case should not be sealed. It's not a case, Your Honor, that involves hypersensitive trade secrets. It's not a case that involves things of that nature. This was something that related to a specific issue with Mr. Glasscock, and so we were fine sealing the documents that Ms. Broom and her client wanted to be sealed. So I just wanted to make sure I fully explained that to the court.
Okay. So how do you propose we do this?
Well, Your Honor, my thought is, so we've agreed on documents in the past that have been filed that Ms. Broom and her client would like sealed. We also reached an agreement that if there are future filings that relate to this issue, specifically Mr. Glasscock having embezzled, or again, it's an allegation, I get that, but it's a significant part of one of the claims, have Mr. Glasscock having embezzled or converted money improperly, we've agreed that we would file those briefs under seal. And so that issue is going to be coming to a head separate, Your Honor, through a motion for summary judgment. So that might moot some of these issues. But the way that seems to be the most appropriate is for us to, pending the court's thoughts on this, seal the documents that have already been filed that we agree should be sealed. And then we have an agreement among the parties that if we file a motion that hits on those issues, which again, it's a discrete issue, we would file those under seal with the court's permission.
Okay. It's going to be really hard to do, but Rhonda, have you been able to get Rose? Sheriff, can you grab my court coordinator? Thank you so much. Oh, there she is. Oh, shoot. Is there any of the clerks here?
Did you want to read one of those?
Yeah, can you see if one of them can come back here?
You want me to just have them call up here?
No, I need them to come here because. All right, so let me ask this then, just to try to work this out. I saw the notice. Did you prepare a proposed order on this, Ms. Broom?
No, Your Honor, I wasn't sure exactly how many edits it would go through, so I felt like I would hear what you had to say today and then present it.
Okay. I think what would work best, I mean, and I understand completely Mr. Schmidt's concern about this. I share the concern about not sealing the entire file, although I think it may be a little unworkable. I think if we can't reach an agreement as to this, then the order needs to specifically state which documents within the file need to be sealed. And I think, so coming up with something like the following, any document that contains Glasscock's name or whatever allegations and stuff, it is instructing the clerk to seal that and trying to make that determination, I just don't think is workable. And so what would make the most sense to me, if we can't seal the entire file, is to have in the order the exact documents that need to be sealed. And we can't just seal part of a document. We have to seal the entire document. And then, something about the parties will agree that any hearings that, or any motions or pleadings that are filed that contain an allegation about Mr. Glasscock, that the parties will agree that those will be filed under seal as well, something like that, so that it's contained in the order. And it might be good to have Veronica, if she could come, because it's pretty complicated.
Okay.
Your Honor.
Yeah.
Your Honor, one other suggestion I have is, so we've agreed on the past documents that have been filed. Oh, sorry, Your Honor. No. So no problem. We agreed with the documents that have been filed in the past that should be sealed. The only document, Your Honor, that I anticipate coming up where that we intend to file that will hit on this issue that Ms. Broom is concerned about is an amended motion for summary judgment. It could be, and I'm only offering this in case it streamlines things. Pending the disposition of the summary judgment, this might be a moot issue, and the clerk's office wouldn't have to worry about navigating this on a going forward basis. We could agree that MSJ briefing could be filed under seal, and then if the court denies the motion for summary judgment, we could revisit this issue. But I can state to Your Honor that we do not plan on filing any documents with the court that hit on this issue that Ms. Broom is concerned about, aside from this MSJ briefing. So that's just another proposal in case it streamlines.
I think that's even less workable, to be honest.
Okay.
I mean, I appreciate the suggestion, but I just don't think that's very workable either. So we have one of the lead clerks. Unfortunately, my lead clerk is on vacation today, and who's here. So it sounds like we don't have an order. Do we have an agreement that the everything on page 4, those specific documents that are listed on page 4 of the notice of hearing, that all of those should be sealed, or?
Yes, Your Honor.
That was agreed to by Rule 11, Your Honor.
Okay, by Rule 11, okay.
In an email.
Okay, well, let me ask the clerk here. So we have an issue involving a sealing motion.
Mm-hmm.
The parties have agreed to certain documents that need to be sealed. They haven't submitted an order to me yet. I would assume you need an order in order to actually seal it. Is that right? Okay.
You need an order to seal the documents.
Okay. I was going to just tell them, hey, you need to seal these documents, but understandably, they've said they need to have an order on that, and that makes sense. I don't fault them for that. What? A broad certification. Okay. So we're going to need an order on exactly which documents need to be sealed, as well as a discussion of what we said. I think it's not a bad idea, Mr. Schmidt, to say that all the briefing in this summary judgment will also be under seal, but I don't want it to be that restrictive, because
understood.
I can't tell you the number of times the attorneys told me this is all we're going to do, and then that's not really what happened. So no offense, I've just been down this road before. And so how quickly can you get me an order on this?
I can do it this afternoon, Your Honor, or when we're done.
Okay. All right. Well, go ahead and get that to me as soon as possible. Make sure it details exactly. I would include in there also the date it was filed, whatever thing you want. So you have a list here of what needs to be sealed, but I would include the date of filing too in the order, like the Carr Holdings and Management's response to Glasscock's motion to compel filed on blah, blah, blah date. So it's extremely clear to the clerks exactly what they're supposed to seal.
Okay, that makes sense.
Okay. All righty. Thank you so much. I appreciate it. We'll get you the order on that. Okay. None of this was on the record, just FYI. So is there anything else we need to put on the record? I guess we have the special exceptions we need to put on the record. So let's go on the record on cause number DC 201463, JAG Financial Services versus Capital Asset Recovery LLC. Counsel, make your appearance.
Constance Groom on behalf of JAG, Julie Glasscock, and Brian Glasscock.
Your Honor, good morning. Grant Schmidt and Tom Melsheimer on behalf of Capital Asset Recovery LLC. And then also on this Zoom call, I have our clients, Mr. Greg Green and Mr. Gregory Green. Okay, so we've dealt with the issue on the motion to seal and how to, I want to note, is there any member of the public, general public here who's going to object to the sealing motion that we just discussed? Okay.
So the court will note that there's no member of the general public here who wishes to object to it. So we'll go ahead and enter the motion to seal as we discussed. Let's deal with the special exceptions next. Go ahead and argue it.
Okay. Your Honor, it looks like opposing counsel filed on behalf of his client a 7th amended petition, counterclaim, answer, yada, yada, yada. I believe that some of the issues have been addressed by that filing, but there are some that have not. And so I'll start with what has, so that we could then kind of cross that out and then move on to the ones that remain, if that's all right with you.
Okay.
Okay. The first special exception was on behalf of JAG, and that was an objection or a special exception to the attorney's fees claim. And the basis of that was that there was no specification as to the basis for recovering the fees, and there was no striation between who all the fees were being recovered against and the basis for the same. It was basically, hey, Chapter 38 gets us attorney's fees against the defendants, but it didn't name or specify. So that was the special exception on that. That has been alleviated with regard to JAG. So the special exception with regard to JAG's contention that that CAR has not specified its basis for recovery of attorney's fees against JAG is no longer an issue.
Okay.
Now, the issue though regarding CAR's ability to recover attorney's fees against Brian Glasscock and against Julie Glasscock is still at issue. The primary issue with that is in the 7th amended petition, the only basis for recovering attorney's fees that is identified is a basis for recovering fees against JAG. They don't specify any basis in the pleading for recovery of fees against Ms. Glasscock and against Mr. Glasscock. So we're still in a position where there's no clarity, first of all. Second of all, in the response to the special exceptions on the issue of attorney's fees for Julie Glasscock and Brian Glasscock, counsel argues that this issue is moot because deposition testimony has now permitted argument for alter ego or veil piercing claims. The problem is veil piercing is a cause of action and it's not been pled. So again, we're still here with lack of clarity. And so from my position and from my client's position, I believe that a special exception with regard to CAR's ability to recover attorney's fees against both Brian Glasscock and Julie Glasscock remains. They have not satisfied that. So I can stop on this issue, this discrete part, and perhaps let opposing counsel respond, or I can keep going. What is easiest?
No, that's good. Let's go one at a time. So Mr. Schmidt.
Yes, Your Honor. Your Honor, I think I can again, this is Grant Schmidt. I think I can short circuit this. So in terms of our counterclaims, we're only asserting that JAG, that CAR can seek attorney's fees from JAG because that's the only recipient of the breach of contract claim. So under section 38.001, JAG is going to be the one liable for attorney's fees. In the actual briefing, what I explained was that this will be a post-judgment issue, but to the extent that there's issues with JAG paying those fees, that will be handled post-judgment as it relates to Julie, Ms. Glasscock, and Brian Glasscock's role within JAG. So Ms. Broom was asking us to amend and providing clarity. We're only seeking attorney's fees from JAG with the caveat that, of course, post-judgment, there might be some issues in terms of collection and payment. There was another caveat, though, Your Honor, where we explained that there are several claims in this case. Brian Glasscock has his third-party claim against CAR. And in that separate dispute, there's a partnership agreement that governs that issue. And the partnership agreement says that the prevailing party in the middle of any sort of dispute about this partnership agreement is entitled to fees. And so all I was doing in the response brief, Your Honor, was just simply saying that to close the loop, we're only seeking attorney's fees for the breach of contract claim against JAG, not Brian Glasscock, not Julie Glasscock. Ms. Broom doesn't have to worry about that. Her client doesn't have to worry about that unless there is a piercing of the veil issue post-judgment. And then separate from that, Mr. Glasscock has filed a claim against Carr, against our client. And for that dispute, if we prevail on that claim, then we are entitled
is all of this clear in the pleadings, though, or that what you've just said?
Yes, Your Honor, it is. So Ms. Broom is shaking her head, but let me just explain, Your Honor. In the 7th amended petition, Your Honor, I stand by everything that's in there. It simply says we're seeking attorney's fees from JAG based on section 38.001. JAG is the only one we've claimed breached the contract. And then, Your Honor, in the answer to Brian Glasscock's claim, again, his third-party claim, we have amended that answer to add the clarity that Ms. Broom was seeking, saying that we will seek fees as it relates to that claim if we prevail based on the language that is found in the partnership agreement.
Can you share screen the portion of the 7th amended
absolutely, Your Honor,
that discusses that second point?
Yes, Your Honor. 1 second.
Your Honor, I hate to interject here, but part of the confusion is there's no special exception to the question of whether they are entitled to recover fees on the third-party claim. So I don't even know why that was amended or addressed. That wasn't even an issue today. So we are not challenging Carr Holdings or Carr Holdings Management's ability to recover fees against Brian Glasscock on that, and that's not even set for hearing today. So as far as, ensuring there's confusion on that issue or not confusion, I'm not really worried about that.
So, Your Honor, with that representation that Ms. Broom just made, I think we've landed the plane on this. So here's paragraph 51. Again, we're only, in terms of Capital Asset Recovery LLC's counterclaims, we are only seeking attorney's fees against JAG based on the breach of contract claim. That's what this says. We're not.
Okay, that point is clear. So the second point about Glasscock and the partnership agreement, where is that pled?
And then I will show you, Your Honor, that one. And Ms. Broom is saying that.
There's no special exception pending on that issue. So that's why I'm confused why we're even talking about that today is the point.
So, okay.
Yeah.
Just for the record, Your Honor, it's somewhat confusing since there are these third-party claims. So I wanted to make sure it was clear for the court. In the answer, actually, this is one of the answers. Let me just, hold on 1 second. Let me get you the other answer.
Okay, then Ms. Broom, what is your objection at this point as to the pleadings on attorney's fees?
The attorney's fees, I wanted to have clarification, and I guess what he's saying is it has been clarified, and that is in the petition, the only pleading now asking for attorney's fees is this one claiming fees against JAG. In the response to special exceptions, counsel argues that Glasscock and Brian Glasscock and Julie Glasscock are entitled to recover fees against them on veil piercing arguments. So I was confused because the response says we can get fees on veil piercing, but the pleading doesn't argue veil piercing. And obviously veil piercing is a cause of action that must be pled, or at best it would be an affirmative defense, and it also hasn't been pled. So my point was, okay, we've got a petition that's been amended that says the only fees that are going to be obtained are from JAG. My concern was then why did the response say, oh yeah, but we can get this via veil piercing? So I wanted that to be clear, but it sounds like opposing counsel's belief is that veil piercing would not be a claim that would need to be asserted, that this could be handled post-judgment. So if that's counsel's position, that's counsel's position. I just wanted to make sure that the pleadings were clear. And as I understand it, I guess they are. They are only seeking to recover fees for breach of contract against JAG. And so that's fine, Your Honor.
That's correct, Your Honor. For this,
all right, guys, we don't have a ton of time here. So what do you need me to decide? Is there any issues that you still need me to decide on the special exception?
Not on the attorney's fees, but on other portions of the special exceptions, yes.
Okay, let's go ahead and get those.
Okay. The next special exception at issue would be Brian Glasscock's special exceptions to the negligence claims that have been asserted by CAR. There are three concerns. First of all, the economic loss rule and the one satisfaction rule. They have asserted a breach of contract claim, which we've just gone over, against JAG. And so they've identified a specific set of damages and specified what those damages are based on, and they are seeking to recover those damages. The problem is the very same set of damages are the same with regard to the negligence claim. And so my point is, Your Honor, that the law does not allow for that. You have to have different damages to support a tort action, because if your damages are sounding in contract, they are barred. The economic loss rule does not permit that. You have to have a separate injury. And in this situation, they're pleading in the 7th amended pleading, they've alleged a bunch of different facts that are new facts. The problem is the damages are the same damages. So unless they complete additional or different damages that do not relate to the damages that are being claimed under the breach of contract, then they are not entitled to recover the same. So my point is, there's nothing underpinned, there are no damages underpinning the negligence argument, Your Honor. Right. That's the first issue with that. There are others, but that's the first one.
Response.
Yes, Your Honor. I know we have limited time. May I share my screen very quickly?
Sure.
So, Your Honor, this is the 7th amendment complaint. This is the actual negligence claim of Brian Glasscock. In paragraph 41, these are the different provisions where we are alleging that he either failed to do something or he did something negligently. These are not the, so for example, these are the two items, Your Honor, that we did add to this 7th amended complaint. These are not the exact same as the breach of contract. In fact, these are separate issues on which we allege Mr. Glasscock was negligent. And those lead to different, so if you go to paragraph 42, those are damages that relate to items A, B, C, D, E, and then there's also F and G that lead to different damages that are alleged here. Obviously, Your Honor, in the complaint, we're not required to give the other side the exact amount that we are seeking. But Your Honor, one reason why this particular case is interesting is JAG is arguing, as it relates to our breach of contract, there's some issues they're saying are not a contract issue. They're outside the contract. And so if the jury finds what JAG wants them to find, which is that there are certain issues that were not governed by the contract, then they will be governed by a negligence claim. And so that is why, so in addition to having claims, Your Honor, that are totally separate from any sort of breach of contract, which we pled at the very least with F and G, the jury, Your Honor, is also entitled to look at this. And if JAG's theory is correct, that there are certain issues that fall outside of the contract, then they're entitled to also be able to find that Mr. Glasscock was in fact negligent in some of his conduct.
All right, special exception. That special exception is denied. Next one.
The next special exception is still on negligence, Your Honor. It's in regards to the employee liability.
Okay.
So it's also on negligence, though. And what it relates to is the fact that they are claiming that they're seeking to allege damages against Mr. Glasscock for duties that were part of his duties as an employee. And there's no employee liability for duties done in the course and scope of employment.
Your Honor, may I respond?
I think that's a summary judgment issue, if that's even true. So I'm going to deny that one. What else do we have?
The claims against Julie Glasscock are the same ones here, Your Honor, the one satisfaction rule, which you had denied previously. So is it your position that since they're based on the same, you're going to deny them as well?
Deny? I'm not sure what you're talking about.
Okay, so Julie Glasscock has also asserted special exceptions, but they are on the same basis.
Oh, on the same basis. Okay, I get it. Yeah, okay. If anything I ruled for Brian, I'd rule for Julie, yes.
Okay.
I didn't know that I'd ruled on the one satisfaction rule, though.
Well, it was, yes, I'm sorry. It was the same thing, Your Honor, and that is that there are no specific damages that have been asserted with regard to the negligence basis at all. They're all the same damages. While I see that Mr. Schmidt is arguing that there are new facts, the problem is new facts as to the occurrence doesn't change the fact that the damages you are seeking are the very same damages you are seeking in your breach of contract. And paragraph 42.
So were you talking about the one satisfaction rule or the economic loss doctrine?
I was talking about the economic loss rule, but as far as it relates to the one satisfaction rule, the problem is the same. All of the claims that have been asserted are accompanying the same set of damages. They're all the same damages.
That's denied as well. Is there anything else on the special exceptions?
Not on special exceptions, Your Honor.
And then I think we also have maybe a motion to compel. Is that correct?
Yes.
Okay. Let's go forward with that. And Mr. Schmidt, prepare a order on the special exception rulings I've made.
And Your Honor, I did submit one to the court that I think is in line with the court's ruling, denying the special exceptions, and that is on file with the court.
When did you file that?
I filed that on, I believe, Wednesday. Let's see, on the 29th, December 29th.
December 29th. I see something on the 30th. Let me see if that's it. Okay. Yep, I got it. I'll go ahead and print that out right now. Rhonda, bring that to me when you can. Okay, what do we have on the compel?
A motion to compel, Your Honor. Opposing counsel, on behalf of his clients, has served a series of spreadsheets that is allegedly a printout from a system that is a record-keeping system where documents are logged. This is my best way of describing it. The problem is the documents themselves that are contained in the debtor files have not been produced to us. These spreadsheets are the basis for the offset damages that CAR is seeking to recover or to apply against sums that are owed to JAG. Our belief is that these spreadsheets as summaries or as documentation showing what is allegedly in a document or in a file are not the best evidence of what the documents say or what the file documents contain. So all we want is to be given the documents in the file, not a printout that was done by allegedly done. We honestly, I'm sorry, Your Honor, let me back up. We've already been going through so many different aspects of this case. I've jumped right in here that, as you know,
I've read this. So you're basically just looking for the underlying documents of the spreadsheet.
That's evidence of what is allegedly in these documents. And so we need to be able to give access to them, and we haven't been. Period. And honestly, Your Honor, the declaration, we filed an objection. I know that we're short on time, but I would really like the court to go through the declaration of Greg Green. It's probably Gregory Green. I believe it is the son, not the father. But the declaration is conclusory. There's no personal knowledge shown. It demonstrates exactly why we need the documents themselves and can't just rely on what other people allege the documents say.
Yes, Your Honor. So, Your Honor, this is an important issue. Before I get to the substance, I in the brief I did, and I want to get to the substance, I did note that this was filed after the deadline for the motion to compel, but I wanted to provide the substance for the court. Your Honor, these spreadsheets are not summary documents. And that is the most important thing that I can convey. Gregory Green, my client, spent a lot of time going through drafting a declaration, explaining to the court and to JAG and Mr. Glasscock and Ms. Glasscock exactly how this is compiled and the work that it would take to do this. These spreadsheets, I just want to zoom out for 1 second. This is an important point. JAG asked us to provide all documents that we believe support our damages and our counterclaims. We did that, and that production included these 3 spreadsheets. A summary exhibit, as the court knows, would be if I took a book and then took out excerpts from that book and then tried to do it in a way that would present to the court or to the jury in a better fashion. These spreadsheets are generated by a software that CAR has created. It's called CARSYS. It's basically auto-populated and generated, but there has to be someone who actually drags and drops the actual files that they in fact want, the individual debtors that they want. There are items in the software, Your Honor, that are not at all captured by the hard debtor files. The hard debtor files are totally separate. It's not like a book that we've then taken and hidden the book from the other side. Most importantly, Your Honor, these hard debtor files are not used on a daily basis. So if the court was to say, Mr. Schmidt, I think you need to go find all these hard debtor files, what we've explained and what Mr. Green set forth in his declaration is that that would be a near impossibility and or it would take significant time. And that is because CAR and its operation relies on the software and the reports that it generates. So does its servicer. And so Ms. Broom's argument is built on the suggestion that this is a summary document where we've pulled and chosen different cells and rows to include and that we're hiding behind some other document. But again, if the court was to say, Mr. Schmidt, in addition to these spreadsheets that are generated, we also want you to go get the hard files, as Mr. Green sets forth in the declaration, that would be next to impossible because those are not relied on a daily basis. They're not relied on the basis of business decision making. And again, this comes back to what are we going to rely on in trial to prove our counterclaims and our damages? Those were the requests for production, and that is what we produced. The spreadsheets that are generated by this software that is the foundation of our company.
Your Honor, if I could go ahead and respond.
Sure.
Okay, so first of all, I understand what opposing counsel is saying that, hey, these hard files are documents that we keep stored away. We just look at the computer to see what the computer says are in these files. And I totally get that. The problem is when you look at this declaration by Greg Green, it does not even tell us how these spreadsheets were pulled together. It says where the information is contained on a computer, but it doesn't say what search terms were utilized in order to get this printout. You've got to remember that CAR's argument is that JAG did not send out notices of intent that were satisfactory with the law, but they have not produced the notices of intent that were not satisfactory. Instead, they say, look, here's a random sampling of the ones that we got, and we don't tell you how we got this random sample. We don't tell you what we did to do it or who did it or how it was done, but hey, we got a random sample, and here's a few of those. And they give them to us. The problem is if you want to claim that you were not able to recover or sell a certain number of files because these notices weren't sent or weren't compliant or whatever they were, you need to provide us with the notices we need to see. How do we even know that these notices were supposed to be sent in the first place? Some of these files are probably Chapter 7, and they can't say whether they're Chapter 7 or not because that information is not contained in the spreadsheet. So we need to see the documents that they are alleging are the basis for their damages because they may not be satisfactory. They may not be a basis for recovery. And all I am asking for is to see the actual documents. I am wanting something more than a spreadsheet that summarizes what.
So Ms. Broom, I share your concern here, but let me figure out exactly what you want. So you want the notices, the allegedly defective notices? Is that one of the?
We want the debtor files that are identified in the spreadsheet, Your Honor. They produce spreadsheets that show all of the debtor files that they were allegedly not able to sell because of our client's wrongful actions, and they've associated a price tag of what they lost based on that. We want to see the files themselves. We want to see what was in there.
You want to see the entire debtor files for each particular
because
debtor that they're claiming that.
Yes.
Okay, that makes sense.
They claim that JAG didn't do its job with relation to these different debtor files. And so we need to see the debtor files. If JAG didn't do its job, then show us the files so we can look at them and see how they didn't. I don't want a simple spreadsheet that says this is why we think they didn't. I need to see the files.
Your Honor, may I respond here?
Okay.
This spreadsheet, Your Honor, it's not a simple spreadsheet. This spreadsheet is what our loan servicers and what CAR relies on. What's in the spreadsheet, we're using the term debtor file very loosely. What's in the spreadsheet is, in fact, it is what is kept on a daily basis and what is used by our servicer. There are notes, for example, in Carsis, which is the software, that are then populated into the spreadsheet when someone asks us for a copy of it. Those notes, for example, aren't found. If we were to go and dig up, there are thousands of these files. If we were to go dig up all of the actual hard files, those notes that Ms. Glasscock typed into the software are not going to be found in the hard file. That is because the report that is generated by Carsis is what we rely on a day-to-day basis and what our service relies on a day-to-day basis.
So let's say this case was, how many debtor files are we talking about total?
There are thousands, Your Honor, in these spreadsheets.
So let's say instead this was about one debtor file instead of all these debtor files. What would be in the system on that one debtor? Would there be a notice in the system? Would there be invoices that were sent out? What exactly would be in the debtor file?
Yes, Your Honor. So there are 30 plus. So in terms of what is on the Carsis generated report, is that what the court's asking about?
No. Let's say this was about one debtor file. Okay. What is in the system about, if we're just looking at a random debtor, what would be in the system about that particular debtor? What's contained within the system?
There's 30 plus different columns of data, Your Honor. And we tagged it as a confidential document, but I can show it to you. I can share my screen.
Why don't we, I'll turn off YouTube if it's confidential. So let me.